down, we can start the session. So, we will like to start now with the first session, specific on the background and the content of the European Directive on the right to interpreting and translating in criminal proceedings. But was this directive really needed? The fundamental obligations of the states to safeguard the citizens' rights and to guarantee a fair trial, also across languages, was already laid down in the European Convention on Human Rights and developed in the case law of the European Court of Human Rights. So we have here with us James Brown, who's working as a translator by the European Court on Human Rights. He will give you now an overview of the language assistance in the criminal proceedings in the case law of the European Court. You have the floor.
Okay, thank you, Yolanda, and thank you very much to Lisa and the TRAFU team who invited me to speak again at one of the workshops. And I will try to make this presentation a bit different to the last one, but obviously I will talk about the main case law of the court that goes back now 60 years. That's when the convention was first adopted in 1950. Just over 60 years, and so there is a lot of case law, and maybe not much evolution in the case law, but there are some basic principles that the court has laid down over the years, and that's obviously very important for the directive. So my purpose is to try to put the directive into context. You may have heard that the drafters of the directive wanted to make sure it was Strasbourg-proof. What does that mean, Strasbourg-proof? Well, it basically means that the directive has to be consistent with the Strasbourg case law, and it was also important to make sure that it didn't weaken at all the existing safeguards under the convention. And in order to do that, you'll see that some of the wording of the directive, and I won't go into too much detail about the directive itself, because obviously Luca will be speaking about that just after me, but you will see in the directive, some of the wording is actually identical to the wording of the court, and the basic principles of the directive go back to the convention rights. So obviously there's a problem of implementation, as we've already heard, and there's even a problem of implementing the convention rights. So obviously the directive rights will be even more difficult maybe to implement because they go into more detail, but we can say that the convention has been successful over the 60 years in ensuring that legislation has changed, and there have been some concrete examples of where legislation, for example, in France and Germany in the early days made sure that there was a free guarantee of language assistance in criminal proceedings, and maybe some of the more detailed aspects of the language assistance have not been developed as much as they should have been, hence the need for the directive in the EU states, of course. The convention covers the 47 states of the Council of Europe, so we go much further than the EU. We extend to Russia, Armenia, Georgia, the whole of Eastern Europe, whereas the directive only applies to 26 states, I believe, because Denmark is not included in the criminal legislation. I think it has a permanent opt-out of that. I know I haven't got much time, and obviously, if you want any more details about the court's case law, you can look at the website of the court, and I have actually produced a list of the most important cases, which you will find in your package. I've actually made some summaries for each major case that I will be talking about, and there are probably a few more. It's not exhaustive, but these are the main cases, and there are quite a number that maybe you've never heard of. Some you may have heard of. Obviously, the case of Kaminski against Austria was basically the main case that's always cited in any connection. In any case connected to language assistance, the court still cites Kaminski as being the founding precedent, and there are some others, but as I said, not much evolution, maybe some clarification over the years. And obviously, as the directive is implemented, it will also be important to follow the future case law. So there may be cases in the future that will go into more detail. Obviously, as in terms of implementation, the convention is a living instrument, and sometimes the court comes up with new principles and new aspects of certain areas. Okay, so the convention itself has many articles, and if you're interested, you can pick up, possibly if there are any left, there's a copy of the convention, in particular in Spanish, over there, because I thought that might be of interest. Otherwise, you can see it on the website. And basically, we'll be talking now about Article 6 mainly, which is the right to a fair trial or fair hearing within a reasonable time. And that is the article that covers directly the issue of interpreting in criminal proceedings. We'll be referring briefly to Article 5, which is more about detention, the right to liberty and security. And it must be said that there are some cases concerning language assistance where the applicant will mention Article 14, which is the prohibition of discrimination, and possibly Article 13, which is the right to an effective remedy. And that will be interesting as well to see in the future how maybe our court and also, of course, in Luxembourg will interpret the issue of effective remedies in the area of translation. Article 5 is not directly of interest to the directive. Without getting into too much legal detail, I know when they were discussing the proposed framework decision, the Council of Europe made some comments and said that Article 5 was really out of the scope of this legislation. Because, as I said, it concerns detention, so it covers also detention for the purposes of deportation. It concerns confinement of people of unsound mind, for example, so it goes beyond criminal proceedings, and that's really why it's not one of the founding articles for the directive, which does not mention Article 5 at all, in fact, even though in one amendment I saw that it was mentioned, but then it was excluded again as being really beyond the scope. So any references I will make to Article 5, this particular article, will just be to show how the court actually protects the right to language assistance in certain areas which may not be covered by the directive. So maybe it goes a bit beyond the directive in this sense of Article 5. But also it must be said that Article 5 and Article 6 tend to overlap, and somebody complaining about the absence of language assistance under Article 6 might also refer to Article 5, and there's all sorts of interlinking between these various articles and paragraphs of the articles. This is the main article which forms the basis for the directive rights, so you may be familiar with this, and paragraph A just talks about a language which the person understands, and paragraph E is actually the right to free assistance of an interpreter if the person cannot speak or understand the language used in court. And of course, without getting into too much detail, again, there's been lots of interpretation of the various words in this article, and very early on it was decided that language used in court, which in the French, as you'll see, is maybe even more precise for those people who speak French. It says à l'audience. It sounds like it's only for interpreting actually in a trial or in a hearing, but the court has interpreted that to mean throughout the criminal proceedings, as we will see. So most of the interpretation of the wording goes back quite a long way now. And as I said, this is the only reference I will make to the actual directive. The important thing then is to ensure that the directive does not weaken any existing safeguards, whether they're national safeguards or safeguards under the Convention or under the Charter of Fundamental Rights of the EU. This is the non-regression clause in the directive. And in the preamble, As I said, it mentions the fact that the rights under the directive have to be interpreted in conformity with the relevant case law of Strasbourg. So a number of questions have arisen over the years, and I won't go into each one in turn, but you should bear these in mind as I go through the case law. You should bear in mind that the court has tried to answer these questions and has usually succeeded. Maybe it's not very satisfactory to some language professionals because sometimes it doesn't go far enough. But the main questions here have been dealt with, and the issue of the choice of translator-interpreter, or the quality, aren't quite so important in the case law. The court hasn't gone quite as far as ensuring that all the interpreters, for example, are registered, etc. And that's something which was a loophole that the directive should fill, as I said, in relation to the EU states, whereas we cover a large number of states. Okay. Very briefly, Article 5, as I said, is about detention. And there was a man, for example, a Frenchman who arrived at the border with Poland. He was returning to Poland with his wife, and he was not given the reasons for his arrest in French, and the court found a violation under Article 5.2. And this one you may have heard of, the Belgian case where a large number of Roma families were arrested in Belgium, and there was only one interpreter for a large number of people. And there was no violation under Article 5.2 for the language issue, but the fact that there was limited language assistance meant that they didn't have access to a proper remedy against their deportation, and that was a key feature. So again, an aspect of language assistance covered by another provision of the Convention, which is actually 5.1, Article 5.1. And Article 5.4 is the right to the speedy review of detention, and there was a case against Latvia where an American man had trouble appealing against his detention. So in fact, he was complaining about the detention order, and that is something which is covered by the directive as well, the translation of any order of detention. So you could say that under the convention system, that would be dealt with really by under Article 5.2. In Mr. Shannon's case, there was no translation, or there was a translation, in fact, but it was delayed. He received it late, and the court found a violation because, partly because of the translation issue in that case. A more recent case, an asylum seeker in Greece who did not receive information in his own language about the remedies available against deportation. So again, under Article 5.4. So I've gone through those quite quickly to come to the main article, which is Article 6. Article 6, if you look at the wording, it says that the right covers free assistance, and the court very early on talked about the meaning of free assistance and looked into the semantic aspects of the word free and gratuitement, which is the French version of Article 6, and found that basically there was a once and for all exemption. So even if the person is convicted, they can't be charged afterwards for the assistance, for the interpreter. So regardless of the outcome of the case, and this is something which is in the directive as well, that the person will never have to pay. However, there is a small exception to that, or maybe a big exception, under the court's case law. If you look at the case of Ackerbingol against Germany, this was a case where when the man was convicted in Germany, they charged him for the court costs, and the court costs included the translation of certain documents in the prosecutor's case file. And the court said that that was not covered by Article 6.3e. So in other words, the court has not protected the right to free translation when it concerns the prosecutor's file, evidence, and that's something which is maybe a grey area that we possibly could talk about in connection with the directive. But so there have been cases where if in a certain country the court costs include translation costs for the benefit of the prosecutor, then maybe that's not included by this right. But this right covers language assistance for the defense and not for the prosecutor. So Mr. Ackenbold is complaining that he suffered prejudice in relation to a national of the country whose case file wouldn't necessarily contain any translated evidence, and so there was discrimination because in his case they had to translate evidence and he had to pay for it, but the courts did not find a violation there. There have been cases against Bulgaria quite recently as well, and there's got some people here from Bulgaria saying that the case law of the Bulgarian Supreme Court is not consistent, and it does provide, the law in Bulgaria provides for free assistance, but in the case of Isya and one other more recent case, the person was charged for it, and the court found violations in those cases quite recently. So it all goes back to Kaminski against Austria. This was where the court laid down the founding principles, and some of this wording, as I said, can be found in the directive. The principle that the guarantee under Article 6.3e extends to pre-trial proceedings and also to written material. In other words, the court has said that written documents, for example, the indictment in particular, should sometimes be translated, but there may be exceptions. It hasn't actually given a list of documents. Unlike the directive, the court has never actually laid down a precise list of documents. And here we're referring to documents which obviously give information about the charge or the accusation in line with the wording of Article 6.3e. However, the court said in Kaminski, and it's repeated more recently in Hermi against Italy, that there's no right to a written translation of written documents. So you may have a right to translation of documents, but it doesn't necessarily have to be in writing. And here as well, you find a similar compromise in the directive, I think, where it allows for an oral interpretation of a document in some cases. And this goes back to the Kaminski case. The court said, provided the person, the defendant, the accused, has knowledge of the case against him and can defend himself, that's the most important thing, and it's not too demanding apart from that. Another thing which the court has never addressed is whether a registered interpreter should be called upon, whether it's sworn or whatever it's called in a particular country, and the court has never actually addressed that issue at all, as it said in Kaminski. Some more recent cases have confirmed that applicants have complained that somebody wasn't on the list, or that they were actually a police officer or a customs officer or whatever, and the court has never actually found a problem with that, because which is maybe an unacceptable limitation and maybe resolved by the convention, by the directive. Yeah. So the other issue is that of quality, and quality as well is secondary in the court's case law. The court has said that if there is an issue with quality that is notified downstream, then if the court is put on notice to deal with such an issue, then the domestic court then should react to that with subsequent control of the adequacy of the interpretation. And extrapolating from Kaminski, the court has said the interpreter must be competent, even though that's not the wording used in Kaminski itself. That's a principle which comes from Kaminski originally. Yes, I'm going through this in chronological order, so you'll see some of the earlier cases, which are probably the most important ones, and maybe a few more recent ones. Brozicek against Italy concerned a man who was given notice of a judgment or an order in foreign language, in Italian. It wasn't his language, and he was a Czech national, and he complained. He requested a translation into his own language, and he wasn't given a translation. And so the court found a violation actually under Article 6.3a in this case. Now, an issue that was mentioned earlier is whether a defendant has a right to interpreting in communication with counsel, and that's an issue which is covered by the directive, but not by the convention. And the court has never actually said that there is such a right when the accused has a meeting with his lawyer, for example. But you can maybe extrapolate from a case like Günger against Germany, where it turned out that the Turkish man in this case could actually speak German, but the implication is that if he couldn't speak German, then maybe he would have had such a right in that situation. Choice of interpreter, again, not very satisfactory. There was a case in Scotland where the Turkish interpreter was complained of by the applicant because he was Kurdish, and he thought that she was biased against him, and that she was also called as a witness for the prosecution, and you know, the interpreter was called as a witness in the case, and the court didn't find any problem with that, provided that the assistance was effective. So basically, it didn't look into too much detail into what went on in the case, but considered that there was no issue there. Yes, I wanted to introduce a Spanish example. In this case, Coban against Spain, there were two decisions from 2003 and 2006. And in this case, the applicant actually complained that there was no proper translation into his language of some intercept evidence. In fact, it was telephone tapping that was done during the investigation. And he complained that it wasn't done by a proper registered interpreter or translator. And the courts looked at the Spanish system sort of briefly and said, if you understand the French, basically it said that there was no obligation in Spain to provide a translation by a registered interpreter. I'm not sure whether that's true now. I know we heard earlier about a new draft bill which concerned these issues, and obviously the issue of qualification is important, but I don't think that's been addressed really in Spain even now. Anyway, the court found that under the Spanish Code of Criminal Procedure, there was no right for this man to have his evidence interpreted or translated by a registered interpreter. And the court said, this was only a decision, maybe it's not so important as a judgment, but the court said that provided the interpreter had a sufficient degree of knowledge, whatever that means, and it's obviously a bit vague. This is a case against the UK where the man was convicted of fraud, Mr. Cuscani, an Italian who was the director of the Godfather restaurant in Newcastle, which sounds a bit suspicious. But basically, he didn't have an interpreter at all, and the court was prepared to rely on the man's brother if need be. In fact, they didn't need to use him. And this was a case where the court found a violation because there was no interpreter. And the court made the statement that the onus was on the judge to make sure that an interpreter had been present. This case can be interpreted as a sort of guideline for courts to be more proactive, and if there's any doubt about the person's capacity, that they should actually act upstream. Again, the limits to written translation, as mentioned before. In this case, Hussein against Italy, the court said that because it says interpreter in Article 6.3e, that may mean that oral interpreting is sufficient for the purposes of that right. And this was mentioned, I think, in the drafting of the directive. It says may, so it's not an absolute rule, but the court has never said absolutely that there should be a written translation of a document. It could be oral. And a case against Romania as well is useful to look at in this connection. I know there's some people here from Romania too. An Italian case, Hermi, a major case, it was a Grand Chamber case, which means there are more judges sitting in the court. And here was really because the assessment of need was different. The Chamber decided that there was an issue of translation because this man hadn't received a translation in Arabic of a particular notice of a hearing. And then when he went to the Grand Chamber, which is a form of appeal against the Chamber judgment, the Grand Chamber found that there was no real issue because the man could obviously speak Italian. I mean, the court doesn't go into much detail analysing the language skills of the applicant, especially as it's several years after the event, but it makes an assumption based on the evidence in the file and decided here that the man must have spoken adequate Italian. And one issue the court seems to look at is whether the document is of a complex nature. So if it's complex, then possibly there's more of a need for translation or interpreting. but the court never really applies this in much detail. It doesn't go into any sort of linguistic analysis of what is really complex in each case. Again, the principle that the courts must ensure the fairness of the proceedings. So regardless of what happens in the proceedings in terms of what the lawyer asks for or what the applicant asks for, the courts should make sure that the proceedings are fair, which includes the right to translation and interpreting. A case against Portugal where there was very poor quality of interpreting, and even the courts listened to the recording of the hearing, but found no actual issue of interpreting because it appeared that the applicant had not actually stated specifically what were the real quality issues. Unfortunately, the court, as I said, doesn't go into much detail about quality and just makes assumptions, partly because the applicants don't always complain about the issue at the time. Obviously, maybe they can't, maybe they don't have a remedy. But the court thinks that if the applicant has not complained at the time, then obviously there was no real problem. And that's maybe a way of disposing of cases, but if there is a positive obligation to language assistance, maybe it should look into more detail about how far the domestic authorities actually analysed the need at the time. Pre-trial proceedings then are covered by the guarantees, and this has been confirmed in more recent years because, of course, the right to a lawyer in criminal proceedings, right from the time of the police custody, has been stated in Saldos, for example, Saldos against Turkey, and that wasn't quite clear from Article 6 for how far it went back, but it does go right back to police custody, and that was the case in Ama, when the man did not, he was a Bulgarian, Sudanese national, but he could actually understand some spoken Turkish, but couldn't actually read the statement that was presented to him. And that was the case where the court said there was a violation, even though he could actually understand in the spoken language, he couldn't actually read it. So that's a good precedent as well to show that there's an extensive interpretation of the words. Somebody cannot speak or understand. If they can speak but can't read, for example, then that means that they require language assistance. And a case against Sweden where the French citizen was in the custody of the customs authority, and the court laid down some principles there but didn't find a violation, but it said that, like in Saldos, access to an interpreter should be provided from the very beginning of the custody. A very recent case, which is not very satisfactory, a Russian man in France who had been through several stages of proceedings over the past 5 years, and after 5 years, the French courts decided that he didn't need an interpreter because he must have known French. They don't seem to have looked into it very, very thoroughly, but the courts actually agreed with the French government and said that because he worked in France and because his children went to school in France, I'm not sure what that has to do with it, but that's what the court said. He must have spoken French, and so there was no violation, unfortunately, because this would have been an interesting case if the court had found a violation. So I think I've kept to the time. They're coming to the conclusions. It's quite difficult sometimes to draw conclusions, as I think it's been mentioned by Luca in his great article on the directive. When you look at the court's case law, you can't always draw conclusions from the very sort of casuistic nature of the case law. In other words, the court applies the principles to particular situations, and then to extrapolate from that with general principles is not always easy. But you can say that from the court's point of view, from the Strasbourg court's point of view, the applicant has to have informed the domestic authorities at the time, and the complaint must be substantiated. There are issues of implementation there. I mean, for example, we saw Brozicek where the court said that it was for the authorities to prove that the man could not speak the language rather than the man himself to prove that he could not speak it. I think Ed Cape, who's a British solicitor who's done some research into the Italian system, said that in Italy today that's not always the case. They don't always implement the Brozicek principle, and that they make people prove that they don't understand, which goes against the burden of proof in Brozicek. So this question of implementation of these guarantees. And there is an upstream obligation to provide an interpreter really only if the person requests one for the court. If the person does not request one, like in Catridge against France, then the court has never actually said that they should still, in case of doubt, provide an interpreter. And that's also a grey area there where you would think that there would be more of a positive obligation in case of doubt. And as I said, downstream there is an obligation if the authorities are put on notice, which again comes up in the directive, that there has been a problem of quality. So thank you very much anyway for listening to me. And if you have any questions, you can either ask me in a few minutes' time. I think there might be a few minutes for questions, or you can actually write to me at the court. Here's my email address. So thank you very much.
So thank you very much for this interesting global overview on the main cases and different aspects of interpreting and translation. It's clear that there's still a need to extend the safeguards on the language assistance in criminal proceedings. The court is the ultimate guardian of the procedure and the quality of the interpreters and translating. The case law makes it clear that the central and essential task will be let down on the defense lawyer, who has to control from the first moment if the right of the language assistance is really effective for his client. So we have still, we are running, the time is running, but we have still the time for 3 questions. So not we are going to the next, yes? Yes? Yes, okay. Oh, I'm sorry. Yes? Can you give your name and function, please?
Sí, hola, buenos días. Mi nombre es Juan Antonio Toro, soy magistrado juez de instrucción de aquí de Madrid. Quisiera saber la opinión del ponente sobre el artículo 1, párrafo 3, de la directiva, cuando en concreto dice: en caso de que la legislación de un Estado miembro prevea la imposición de una sanción para infracciones menores por parte de una autoridad distinta de un tribunal con competencia en materia penal, pero la sanción puede ser objeto de recurso ante este tipo de tribunal. La presente directiva solo se aplicará al proceso ante dicho tribunal a raíz del recurso. ¿No considera usted que al establecer ya la sanción estamos privándole o restringiéndole un derecho a conocer de qué se le imputa? Y segundo, ¿se han planteado ustedes que en algún sitio es derecho interno nacional el imponer una sanción en el ámbito distinto al tribunal? Solo quería saber esas dos opiniones. Muchas gracias y disculpe.
Okay, yes, I didn't quite get the second question, but anyway, the first one, maybe we can come back to the second later. The first one, there is a problem, I think, with Article 1.3, and maybe Luca will come back to this, or even Mauro later. But Article 1.3 of the directive excludes, at least at first instance, the sort of minor offences which are covered by a court. Sorry, an authority other than a court having jurisdiction in criminal matters. I think the Strasbourg case law actually There's a case called Ozturk against Germany, for example, which shows that the administrative offences, or for example, traffic fines, offences covered by administrative proceedings, the example in Germany, are covered by the right to language assistance. And I think that this is an aspect where the directive may not be quite in conformity with the convention, or at least the case law. Because you're right, that if somebody is involved in such proceedings, and obviously there's already a sanction which might go down in the criminal record, or some sort of record which might stop them maybe obtaining a visa for the States or whatever, then there's obviously a problem there, and the person deserves language assistance to be able to defend himself. So I think that there's an issue that needs to be worked out, maybe in terms of implementation. And I think this was obviously a compromise when the directive was being drafted, to make sure that the assistance didn't extend too far to other types of proceedings. But we can discuss this maybe a bit more later. But can you just clarify your second point, actually, because you were talking about whether a sanction should be applied, or...
Sí.
Yeah. Yeah.
Sí. Yo le traslado el caso, usted lo ha mencionado, Alemania, pero es en España, en la Ley Orgánica 5 del 2000, que en supuestos referidos a menores de 18 años, el Ministerio Público, que no forma parte del tribunal, puede desistir del procedimiento. Si a este menor no se le hace la interpretación de la acusación, está usted, desde mi óptica, restringiéndole de un derecho constitucional reconocido. ¿Por qué no se le va a aplicar? Porque la directiva dice solo se aplicará cuando sea susceptible ante el tribunal, vía de recurso. Solo, perdóneme, estoy leyendo. La presente directiva solo se aplicará al proceso ante dicho tribunal a raíz del recurso en cuestión. Pregunto.
Yes, yeah, I think that's right. I think I've covered that issue maybe because Article 1.3, which talks about the fact that the language assistance will only be provided on appeal, maybe is not sufficient. And I think the court's, our Strasbourg court's interpretation of Article 6.3e has this autonomous notion of the word charge and the autonomous notion of criminal proceedings, which means that however proceedings are classified in a particular state, it can be covered by Article 6.3, Article 6 as a whole, because they basically amount to criminal proceedings according to the meaning given to them by the court. And so even if, for example, I think you mentioned a minor, or there may be proceedings that would be called something else in a particular country, our courts would look at that and say, you know, if that is really a charge within the autonomous meaning of Article 6, then the person should have those fundamental rights under Article 6. Yeah. Yeah.
Okay, I think that we have to go further now, and your questions can come later on in this workshop still before. We will start now with Mr. Luca de Matteis of the General Secretariat of the Council of the EU. He will present you the EU directive, the legal background, and the content. The floor is yours.
Thank you very much, and apologies, I will speak seated because I need to look at my own slides, otherwise I don't know what to say, and I wouldn't like to turn my back to you having to do that. Well, first of all, I work at the General Secretariat of the Council of the European Union, but as a seconded national expert. I have had 10 years of experience in criminal courts in Italy, my country, and I've dealt there also extensively with questions of translation and interpretation, both in theory and in practice. So this is a topic which is particularly dear to me. obviously everything which I'm going to say here draws on that experience and is entirely my own personal opinion and not that of the institution for which I'm working for now. And I hope that also the question which has been asked now will become maybe a bit clearer in the course of my presentation, which I hope to keep as brief as possible. This is more or less the list of topics which I would like to address. The background, the legal background against which this directive has to be set has been photographed by the Commission in its impact assessment, which it has drafted prior to the presentation of the proposal for this directive in 2009. The reference to this document, SEC 2009-915, you can easily find it on the internet if you are curious. In synthesis, what the Commission pointed out is that it is true that all member states of the European Union are parties to the ECHR and are therefore bound by its provisions. But in practice, there are a number of issues on how this binding force is reflected in the legislation and in the practice of member states' regulations in the field. First of all, there is an inadequacy of spontaneous compliance with the ECHR. Member states do not often respect the standards set by the ECHR, not even when they have been repeatedly sentenced by the court for their violation. Sometimes it's the legislation which presents shortcomings. Sometimes the legislation in theory could be compatible with the standards set by the ECHR, but in practice it is applied in a way which is not sufficiently adherent to these principles. And then, of course, there's the whole question of professional qualification and the assessment of the quality, on which, as James has pointed out, the ECHR is virtually silent for a number of reasons, including the fact that the ECHR has to speak to 47 member states in reflecting extremely different national situations. So what to do about it? EU legislation. And first of all, the question which has to be asked is, what can the EU do about a problem like this? And what the EU can do is written in the treaties, because, as you know, the European Union is not free to do what it wants on a certain topic. It can only approve legal acts, legislation, in as far as the member states have given it the competence to do so, and only strictly within the limits of these competences. In the field of criminal law, the relevant article is Article 82 of the Treaty on the Functioning of the European Union, which says that the Union can legislate. I'll lead it to your reading in another moment, but what presses me here is the reference to the fact that the EU can legislate on the rights of individuals in criminal procedure. So the boundary of a piece of EU legislation which addresses the question of translation and interpretation in criminal proceedings is strictly bound to the protection of the individual's rights. We will see that this has reflected itself negatively on a number of aspects of this directive. First and foremost, for all that concerns professional qualification of interpreters. It has been maintained in the course of negotiations that the EU was not competent to pass legislation requiring a certain procedure or certain requirements for the qualification, and that this sector should be addressed by the member states in the process of the implementation. There are also other boundaries, and here I refer already to what James has already said about the relation of this directive with the complex of legal acts which set the rules on the respect of fundamental rights in the EU. And we have two provisions in the directive which set a minimum and a maximum, so to say. The minimum is Article 8, this non-regression clause to which James has referred, which says that the directive and the national legislation of the member states when implementing this directive cannot fall below the standards set in the ECHR and in the EU Charter of Fundamental Rights. So this is, so to say, the minimum level below which the legislation cannot fall. Recital 33 sets something which is a maximum in a way, and it opens the interpretation of the directive to future expanding interpretation of the Court of Strasbourg and of the Court of Luxembourg on these rights. So if in the future these two courts raise the standards for the protection of the right to translation and interpretation, this case law will become part of the interpretation of the directive, and member states will have to respect it. I will skip this slide because I'm even ashamed to have it after James' presentation. I'm sure you can refer to that. It was just a brief reference to the main cases which set sort of the main reference point for the directive. And we'll go then to the content of the instrument. Well, first of all, what does the directive apply to? And the objective scope is set out in Article 1, and in particular in Article 1, Paragraph 1, where it says that the directive applies to, concerns the right to interpretation and translation in criminal proceedings and in proceedings for the execution of the European arrest warrant. Now let's start first of all by criminal proceedings. What are criminal proceedings? No one knows, in the sense that there is no definition of criminal proceedings. However, as we do here, what we will do for the rest of the directive, when there is a term which doesn't have an explanation, we will have to link it to the case law of the European Court of Human Rights, which has many occasions defined what a criminal proceeding is, not for the fun of defining it, but simply because when you have something which is a criminal proceedings, then certain rights laid down by the convention apply. So it is important in certain cases which are in a gray zone. We're not talking about your typical criminal proceeding which everyone has in mind, but there are situations where certain types of proceedings which may appear of a different nature in reality have the effect of deciding whether a criminal sanction has to be imposed or not. And you have the reference to the case law here. The question of minor offenses, which the question of the colleague was referring to, there's a story behind this provision, which you will find copy-pasted in all directives of European law which deal with procedural rights. The case to which we are referring is typical of the legislation of the Scandinavian countries, and if my memory doesn't fail me, of Scotland, whereby the police, during the course of roadside checks, when they stop a driver for certain offenses such as driving above speed limits, are able to impose on the spot a fine which is considered a criminal penalty. Now, the preoccupation of these member states was that the policeman who stops a car with a foreign driver in the middle of the countryside in Sweden would have to call an interpreter before he can impose a fine. And the compromise found was that to leave this phase as flexible as possible, but also to provide the possibility that interpretation be given at a later stage when actually the person has the possibility to appeal in court against this fine. So it's a simple matter of practicality to avoid overburdening a proceeding when the guarantees can be given at a later stage. In the case mentioned by the colleague, this would not be the case because that would fall within the framework of an ordinary criminal proceedings. And there, all authorities, be they judicial authorities or investigative authorities, have the duty to ensure the respect for these rights. The directive also extends to the European arrest warrant proceedings. I will not dwell on this, I don't have the time, but let it suffice to say that it is quite important extension of the scope, because European arrest warrant proceedings do not necessarily fall within the general concept of criminal proceedings. The temporal scope, when do these rights apply? So until now we've seen to what they apply, now when they apply. Well, there has been a development in the course of the negotiations which have led to the